February this year and signed by the President on the 24th. The law is the first essential step along the complicated and very important way to judicial reform. This law is aimed, first of all, at cleaning up the judges' collegium, at strengthening the disciplinary responsibility of judges, and it has to provide for every citizen the opportunity to go to court and get a just decision there. But of course, this is only a first step, and there's a lot of work ahead. Most of the clauses of the law become active on the 28th of February. At the moment, already the work of the High Council of Justice was blocked, and the clauses that pertain to the High Council of Justice are already enacted, and they will have to either appoint or elect the members of the High Council of Justice. So we expect that it will start to work soon, and this will also relate to responsibility of judges and to their dismissal as well. This week there was a meeting with members of the Venetian Commission where they agreed that in the nearest future the Venetian Commission will provide its conclusion about the law, and we are very grateful to them for their understanding that the terms are very short and for their agreement to work in a respective way. I'd like to dwell on the following issue. At the moment, we see in media some news that this law strengthens the authority of the parliament and the president as far as the influence on the judiciary is concerned, so there's a political factor in this law. I'd like to emphasize that the authority of political bodies are decreased by this law, and this law cannot introduce amendments into the Constitution, but everything that was possible apart from making amendments to the Constitution was made. And this pertains also to appointment and dismissal of judges and to the responsibility of judges. The highest qualification commission of judges is an independent body that is being elected by legal community and judges, and this is the body that has to provide for the control of the judiciary. Any procedures according to the law, all that pertains to appointment and reappointment of judges, also bringing them to responsibility, and dismissal of judges become maximally transparent. Public has access to any sessions of the highest qualification committee and High Council of Justice, and there is a possibility for public control. Besides, the procedure of election of members of those bodies was improved, and there is a aim to maximally depoliticize this, and the president will appoint the members of the High Council of Justice only on the basis of an open contest selection with the participation of the public. I'd like to also mention that the next steps as far as the reform of judiciary is concerned are in the amendment of the constitutional system. As far as the strengthening of independence of judiciary is concerned, also amendments to the procedural legislation, also changes on the advocacy and prosecutor's office laws, and on the fulfillment of court decisions so that citizens get a real possibility to have implemented, not just pronounced decisions. The set of these changes has to provide for the right of citizens to fair trial, and I'll be glad to answer your questions. Any questions, colleagues? Yes, there are. Could you introduce Internet Publication Censor? Could you please tell us, could you specify the amendments to the Constitution? What are the clauses that the President's administration is working on, and when we may see this in the Parliament? Thank you for the question. The administration of the President does not prepare any amendments to the Constitution. The Constitutional Commission will do this. This is a public body created at the initiative of the President, but first of all, it will be composed of lawyers, specialists in constitutional law, and representatives of public who have special knowledge. The range of decisions that have to be made within the constitutional reform is rather broad, but if we talk about the reform of judiciary, this is the improvement of the structure of judiciary, the solution of the issue about 3 or 4 stages in the court system, also a body that will be responsible for representative functions and for disciplinary responsibility. At the moment, you know that there are 2 such bodies, but Venetian Commission has more than once recommended to have one single body. Also, the issue of judges' immunity. Again, the Venetian Commission has more than once recommended that this immunity is narrowed to functional and doesn't have such a broad sense as now, and the raising of demands for the candidates for judges. Now you know that it is enough to have 25 years of work record to apply for judge's position, but of course in many cases this is not enough to receive qualified and quality trials, so this is all has to be decided within the framework of constitutional reform.
I'm the lawyer which is representing the victims of Aftermaidan, and any reform, judicial reform, cannot be implemented without addressing the problems related to the revolution of dignity. We have more than 600 judges who are the cases against who are filed. What is your position as the representative of the presidential administration? Many believe that the problems with judiciary were related to the influence of the presidential administration. How should the issues be resolved in relation to the judges who were involved into all the cases related to the revolution of dignity, and also what would be the position of the presidential administration in the future as to the lustration legislation and as to renewing the trust to judicial system? On any changes planned there? Thank you for your question. You asked basically several questions. So as to making the judges responsible, how this should be happening, I believe there's one correct answer to that. This should be happening in accordance to the law. There are 2 options. If there is a criminal violation in the actions of the judge, then the law enforcement bodies forming certain evidence base have to file the criminal case, then submit this case to the court, and then there is one thing here to prove that the resolution was incorrect, then this resolution has to be cancelled by the court of the higher instance. But in case of with Aftermaidan, it's not always easy. If the evidence is not enough, then still there is the way of disciplinary responsibility. And here I would like to concentrate on the norms which are being introduced in the law that has been just published. One of the main objectives was to strengthen, to make efficient the system of disciplinary responsibility of judges, which until now was not properly operating. And that was done in two aspects. First, the grounds for disciplinary responsibility are expanded and specified so that they cannot be interpreted at somebody's discretion. And then there were, so that there are bases, the presence of which means that the disciplinary case should be filed and take it to applying disciplinary sanctions. And the second thing is expanding disciplinary sanctions. You know that till now there were just two types of disciplinary sanctions, was dismissal and reprimand. Reprimand was like a conditional sanction, and dismissal is a final sanction. It was, and again, the grounds for that are quite serious, and the Venice Commission paid attention to that, and the European Court on Human Rights, Volka versus Ukraine, was talking about that. That was not used often. There were several cases when it was applied without proper grounds. Now the list of sanctions is being expanded, so that the principle of adequacy of punishment for violations is implemented. There are such sanctions as removal from exercising legal activity and others. And application of such sanctions is possible in cases when there's not enough substantiation for applying the criminal responsibility. Lustration law. The law on the ensuring the right for just court provides for the special procedure of assessment, and all the judges are to go to do that. There are two parts in it: assessment of the professional standards and assessment in relation to anti-corruption legislation and moral qualities of the judges. And this way we will clean our system from the corrupt judges and politically engaged biased judges, and also the judge who wants to become the judge of the higher instance. If the judge moves from one level court to another level court, every time he will have to pass this evaluation procedure, and this will be the basis for the competition to get a specific position of a judge in a specific court. So only the best judges will get to higher courts, who several times pass the filter and prove that they are better than other candidates. Any other questions? Malishka, I am the member of the National Union of Journalists of Ukraine. How, in a judicial reform, you will, how the reform will define the status of judges on the occupied territory, for example, in the Crimean Peninsula, and what's the position of the presidential administration to the courts which exist there? The position is very simple. If the judge is loyal to the oath, he can and should be transferred to Ukrainian court, and he can such judge will get all the opportunities to exercise justice there. If the judge moved to work to the Republic of Crimea, or to so-called courts which are created on the territory of DNR and LNR, then these are the cases of violation of oath. Such judge will be dismissed in accordance from his position in accordance with the law. There are no cases of dismissal because of one simple reason. The Supreme Council of Justice, which is a key body in the procedure of dismissal of judges, is not operating. The activities has been blocked for more than a year, but the law that was published yesterday allows to restart the work of the Supreme Council of Justice to organize the elections, and during the 60 days, starting from today, the Supreme Council will start operating. Then, according to the Constitution, such judges will be dismissed. According to the Constitution, according to the legislation on citizenship of Ukraine, the judges who have already received the dual citizenship, Russian citizenship, they even received the certificates of judges in Russian Federation. In accordance to Constitution, can they be automatically dismissed from work? Because in accordance with the presidential decree, in accordance with the resolution of any administrative court, and there will be no commissions are needed, no high instances are needed. There is an international procedure of dismissal of judges. If the judge changes his citizenship, takes an oath of another country, then automatically he's deprived of his status or her status. You understand, we have one of the main objectives, and that was one of the main objectives of the Revolution of Dignity, was to create the legal state, which means observing the Constitution. The Constitution defines all the grounds for dismissal of the judge and the procedure of dismissal, which is then developed in the laws. But unfortunately, in this case, unfortunately for the example that you are giving, there's no notion as automatic losing by the judge the status of the judge. There is a procedure which is to be followed. Thank you. When you are asking the question, you get an answer, and then you want something else from the speaker. Thank you for the information. Our next briefing will take place at 12:30. Colonel Andriy Lysenko.